On the item number 3, presentations, 3.1, the Wasaga Beach Investigation briefing. And I'll now pass the floor to our CAO, Andrew McNeil. Andrew?
Thank you, Mr. Mayor. And could I get the clicker right there? Thank you. Okay, thank you so much. Before I start, I'd just like to acknowledge that I'm joined by Mr. John Mascarin, who has acted as external legal counsel in this matter for the municipality. I usually do not prepare speaking notes, but I did today, so forgive me while I will read some of my prepared notes. I thought this matter was serious enough that I wanted to make sure that I covered this accurately. Mr. Mayor, members of council, well, I did not work for the town of Wasaga Beach between the years of 2018 and 2022. I am aware that there were widespread rumors within the municipality at that time pertaining to potential wrongdoing within Town Hall. At the time, given the politically charged nature of the town, I wasn't sure how much credibility to afford what I was hearing. Upon returning to the town as CAO, I wanted to be extremely cautious in how town staff responded to any and all of these rumors. My message to staff was quite simple. Our priority is to move this town forward and to implement council priorities. Our preference was not to spend the next 4 years looking through the rearview mirror, chasing rumors and speculation. That said, I did ask staff to bring to my attention anything that they felt was of a suspicious nature or questionable nature. It did not take long for a multitude of things to arrive on my desk. And the presentation before you today outlines a few of those matters that have been uncovered that are, in my opinion, of a highly questionable nature. The matters that I will provide an update on pertain to 4 issues. The first is the business park transaction that occurred in 2022, the ongoing efforts to redevelop the beachfront with a specific focus between 2018 and 2022, the purchase of the land that our current arena library is nearing completion upon that occurred in 2019, and destruction of records between 2018 to 2022. For those who are not familiar with the background as it pertains to the business park transaction, I wanted to provide some high-level key points just so the community can get a sense of what was involved in this deal. Key components of the deal included turning over town-owned lands in the business park to Zancor in exchange for servicing the lands. The deal was predicated on the delivery of a business park with employment uses only, and that's a very important point to stress. It was intended for employment, not for other uses. The land was kept in trust for Zancor until 2022, when it was conveyed to Zancor just a few weeks before the election. And the business park was exempted from all development charges in perpetuity. The business park transaction is troubling on many levels. To begin, I'd like to qualify the fact that these lands are not located within a community improvement area or commonly referred to as a CIP. That's a technical planning term that a lot of folks are probably not familiar with. For those who are not familiar with what a CIP is, it's a planning tool that affords municipalities the opportunity to use incentives to spur on economic development activity that might not occur but for incentives being offered. Before I speak in detail about some of the financial implications of this transaction on the town, I'd like to invite Mr. Mascarin to speak to 2 matters. And the first pertains to issue of bonusing, and the second pertains to the issue of development charge exemptions as they pertain to the business park. Over to you, John.
Mr. Mayor, members of council, thank you for the opportunity to speak. Andrew, thank you. For those of residents here and watching, the question of bonusing is something that's covered in the Municipal Act. It's a long-standing provision. It's currently in Section 106 of the Municipal Act, and it effectively provides this. A municipality can't sell land at less than fair market value to any commercial enterprise and other entities, and a municipality cannot provide a waiver or exemption in whole or in part against any charge, levy, or rate. It's a rule that's put in place in the Municipal Act to ensure that municipalities don't battle each other, essentially, to give undue incentives to incentivize commercial enterprises to come to their municipality. It's a long-standing rule, as I've mentioned, and so that, in a sense, is what bonusing is. It's a primary rule for municipalities. There are a number of exceptions, and Mr. McNeil has spoken to the first one. One of the exceptions to the rule against bonusing, where you can't do those enhancements, incentives, is in a community improvement plan, which is permitted under Section 28 of the Planning Act. As is indicated on the slide, we were asked to look at the transaction, the whole transaction, dealing with the business park matter, and it is our legal opinion that there may have been some illegal bonusing that had occurred when the lands were transferred in 2022 for the consideration at which was listed on the transfer, given what the deal was in 2006. And it's our legal opinion, again, that was provided to council enclosed, that the exemption that is currently in the development charge bylaw appears to be unlawful. It's not something that's permitted in the Development Charges Act, in our view. That, in a sense, talks to bullets 2 and 3, Mr. McNeil, that I think you wanted me to speak about, and you'll see that there's some other points up there, which is what led us to our conclusions. The construction of the services were valued at $1.4 million, and those were listed in the transfer as the consideration. And yet there was an appraisal of land in February of 2022, which listed the land or appraised the value, valuated it at $8.2 million. There was an updated appraisal that was done in November of 2023, which looked at the mixed-use development of the land, which is perhaps what's being proposed now, at $21.7 million. And again, the consideration that was listed on the transfer was only $1.4 million. So I'll turn it back to you, Mr. McNeil.
Thank you so much, John. And I'm going to go over these numbers just one more time, because these are important for the community to understand. So prior to the conveyance of the lands to Zancor in August of 2022, staff worked to prepare a detailed estimate of the value of the services that were installed by Zancor. In 2006, the value was estimated at $1.4 million. Staff then put a 2022 value on that work of approximately $1.8 million. To inform the transaction, an appraisal of the lands was completed in February of 2022 by HG appraisers. The assumption applied that informed that appraisal was that the lands would be used for employment uses only, so no residential was permitted. The value of the lands was estimated at $8.2 million at that time. My next slide will explain this point in greater detail. However, in the summer of 2023, I reached out to HG appraisers and asked if they could prepare an additional appraisal for the lands based on the plan that was submitted by Zancor, which I will describe momentarily. That plan factored in mixed-use development and standalone residential. At HG's suggestion, I agreed that the second appraisal should be reflective of market conditions that were present at the time of the first appraisal, so that we are comparing apples to apples. The second appraisal produced a valuation of approximately $21.7 million. With respect to development charges, I asked the treasurer to estimate what the value of the foregone development charges were to the municipality based on the plans that were submitted to the town by Zancor. That value is estimated at approximately $7.6 million. It's important to note that with tens of millions of dollars at stake, the town got absolutely nothing for an extremely valuable piece of land. Following conveyance of the property, the town did not receive any money. A really important date to understand is December 22nd, 2020. This is the date that Zancor submitted their plans for the business park to the planning department. They were requesting consideration for rezoning and official plan amendments to pursue a mixed-use development that included residential. The entire deal with Zancor was predicated on the development of employment uses within a business park. I'd now like to ask John Muscarin to comment on the impact of the submission of a mixed-use development and how that impacted the 2006 agreement, in his opinion.
Mr. Mayor, members of council, as Mr. McNeil has indicated, the essential term, and it's been actually stated that way several times, the essential fundamental term, the root covenant in the 2006 agreement between the town and Zancor was that there would be a development of a business park. My submission to you is the applications that were made in December of 2020 that seek to have the lands rezoned and redesignated under the official plan for residential basically erodes or eradicates the fundamental basis of the entire deal of the business park. So it is very concerning, I think, for the municipality. One of the terms in the deal was that the lands would be held by the municipality and then transferred, and that actually occurred. And it appeared to have occurred with the knowledge of some of the staff at the time that there was planning applications that would fundamentally change that business deal on which the transfer was stated to have been based on. That is very problematic in my view, and I think Mr. McNeil said it really well. Really highly questionable actions occurred.
Thank you, John. It was well known by the CAO and broader staff that Zancor had intentions to build residential. They did not make this a secret. They submitted the plans to the planning department in 2020. We've also uncovered, dating back to 2011, signs were erected on the business park lands by Zancor indicating houses coming soon. The CAO at the time quickly advised Zancor that they needed to remove those signs. So dating back over a decade, the intention to build non-employment uses was well known by staff within this corporation and the CAO. Senior staff saw what was going on and advised the CAO prior to the conveyance that he should shift course. They believed that this should have triggered a renegotiation of the deal. Sitting here today, I believe that should have triggered a renegotiation of the deal. Their advice was ignored, and it appears that the CAO misled council on the implications of this transaction and that the public trust may have been violated. The implication of this for the taxpayer of Wasaga Beach is a loss of between $16 million and $30 million. The second matter I wanted to raise is beachfront redevelopment. Unlike the business park, the beachfront does have a community improvement plan in place. This was put in place when I previously worked for the municipality back between 2014 and 2018. This does provide the municipality with more latitude to be able to negotiate deals. There are a couple matters that are concerning with what went on during 2018 to 2022. The first concerning issue is the path that was taken to bring Zancor to the table. An RFP was issued that clearly stated that the lead development partner can only partner with a minority development partner. Baylock, also known as Baycliff Homes, was the successful proponent of that RFP process. However, this situation was manipulated to bring in Zancor. Zancor showed no interest in developing the beachfront prior to this. They did not even submit a response to the RFP, yet they ended up as the controlling interest partner in Wasaga Baylock Limited. This controlling interest was 75% control. I find this detail extremely concerning. Further, 2 appraisals were prepared for the beachfront. The first was dramatically higher than the second. It was in the hands of the mayor and CAO at the time. However, it was never shared with council, despite repeated questions from a member of council who is still with us today about the land being undervalued through the transaction. A CIP does allow land to be sold under market value. However, the issue at play is that information was deliberately withheld from council that had a direct impact on undermining the town's position in these negotiations. The mayor, CAO, and all officers of the corporation have a fiduciary duty to the town, not to Zancor, and this information should have been shared with council. The third issue that I wanted to raise relates to the land purchase for the town's Twin Pad Arena and Library. 2 details are intriguing here. The first, despite the fact that council intended to consider the various potential sites to purchase for the TPAL on March 7th of 2019, the CAO brought forward a report on March 5th, 2019, 2 days before council would be considering this matter, recommending the sale of the Chamber of Commerce building to the owner of the adjacent lands that were ultimately purchased for the TPAL. If you're not familiar with the Chamber of Commerce building, the site where you can see on the bottom left where the current arena and library is situated, it's the bottom left corner, which used to be the town-owned Chamber of Commerce building. I find it incomprehensible as to why the CAO, after sitting on the chamber lands for years, felt it necessary to advance this transaction 2 days before shortlisting the sites for the TPAL. Knowing full well that the former Waterworld site, the site that was inevitably purchased, was likely the front runner. I believe the prudent thing to do would have been to pause any disposition discussions on the chamber site until after council had selected a site for the TPAL and then determine if the chamber building was required. Had council proceeded with the sale, the town would have been placed in a position of having to buy back a site that had just sold within a matter of days of closing the first transaction. Thankfully, council said no to this proposal from the CAO. The second interesting aspect is that the town paid approximately $2 million more than the appraised value for this site. There's a pattern here of selling land below market value when the town owns it, or in fact gifting lands, which was the case with the business park, while paying more than market value when purchasing lands. The net impact is that the taxpayer lost tens of millions of dollars at a time when we're struggling to absorb a $60 million expenditure for a new arena. One of the more serious issues that I wanted to share with council today and the public is the issue of records destruction. For everyone's benefit, both the Municipal Freedom of Information and Protection and Privacy Act, also known as MFIPA, and the criminal code speak to records retention. Both consider intentional records destruction outside of any policies and procedures to be an offense. While it is certainly possible that there may exist a more egregious example of records destruction in the province, the fact is that we are unaware of one. The scale of records destruction that has taken place within the town of Wasaga Beach appears to be unparalleled. The destruction that has taken place in Wasaga Beach has spanned multiple years and has included hundreds of thousands of records, both digital and hard copy. In 2018, Interim CAO Jerry Marshall began to notice that emails and subfolders were being deleted from his email account. Upon questioning the Chief Information Technology Officer, he was advised that the former CAO had been granted access to the account, and it was he that was deleting records. The former CAO's access was immediately revoked. In 2023, shortly after assuming the role as CAO, I was informed that the former CAO had been covertly working at the fire hall in 2018, destroying records following the appointment of Jerry Marshall as interim CAO. As a thank you to staff for keeping his activities quiet, the former CAO provided staff who became aware of his presence with gift cards. We have one of the gift cards that was provided to a staff member. Shortly after the 2022 election, Mayor-elect Smith received numerous calls from town staff advising him that the CAO was leading a massive records destruction campaign. Mayor-elect Smith reached out to the CAO requesting that all records be maintained. After not receiving a response, he followed up with a similar request to the Chief Information Technology Officer and the clerk. Both responded advising that records would be preserved. What followed was absolutely egregious. Under the direction of the CAO, the Chief Information Technology Officer made an urgent request to CompuSolve, the company that maintained the town's email backup server, to wipe the server. CompuSolve responded by questioning the direction, and we have emails that show they were saying, are you sure you want to do this? The response was, yes, ASAP. In a direct conversation that I had with the Chief Information Technology Officer in the summer of 2023, he indicated that the CAO had also been trained on how to permanently destroy records and that he was actively carrying this out. Further, staff have since come forward to share that they witnessed the CAO training other senior staff on how to permanently destroy records. Shortly after the 2022 election, and upon learning of some of the above, Interim CAO Marshall commissioned a forensic audit to try and recover records. Some electronic records were able to be restored, but a significant volume have been lost. This includes all council emails from 2018 to 2022, save and except for Councillor Belanger, who I believe still has access to his emails from that time period. Everyone else has had their records wiped. This is a significant issue for the municipality. It is unfortunately common for municipalities to end up in litigation, which helps Mr. Muscarin keep in business, from time to time on various matters. We simply do not know how extensive destruction of records has compromised the municipality, and should the town's position in litigation be compromised because records were destroyed, it may leave those individuals who carried out the destruction open to personal liability. Additionally, it may be difficult, if not impossible, to respond to future FOI requests, Freedom of Information requests, if the records have been destroyed. We will need to seek guidance from the Attorney General to understand the precarious position that this has put the municipality in. While we do not yet have a full understanding of the extent of the destruction as it has taken place over many years. We do know is that there was a frantic push to destroy records after the 2022 election. This leads one to question, what were the officers of the corporation, and more specifically, the CAO, trying to hide? Combined with some highly questionable real estate transactions, I find this incredibly troubling and questionable conduct. Shortly after being made aware of the magnitude of what the town was facing, I reached out to John Muscarin to seek legal advice. That advice was that I had a fiduciary duty to disclose what had been uncovered to both council and the Ontario Provincial Police. That disclosure took place earlier in the summer of 2023. As CAO, I have engaged in multiple conversations with the OPP and have shared what we have managed to uncover to date. This matter has been turned over to the OPP for their review, and they will determine if any further action will be taken. In addition, the town has and will continue to enhance our records retention policy to try and prevent this abuse from ever happening and again. I wanted to pause just quickly to allow our clerk to speak to this and some of the measures that we're going to be taking to try and prevent this from happening. Over to you, Nicole.
Thank you, and through you, Your Worship. The Clerk's Department has created a project scope for records that includes enhancing all our policies, looking at current agreements with service providers. We'll be looking to ensure that emails are retained for a 5-year period moving forward as well. We are establishing training for all staff on records, on NFIPA, routine disclosure within the organization. As well, in the 2024 proposed budget, we have secured funding to purchase an electronic records management system as well. So these are the steps that we're taking. We've provided council last meeting with a routine disclosure policy, and you will see more policies and agreements come before you in the near future.
Thank you, Nicole. And when that policy comes forward, it will be my strong recommendation that no staff, including the CAO, should ever have the ability to go in and destroy records. That should just be a non-starter. Further, the town has created a whistleblower program to protect anyone who wishes to come forward and report what they believe, if they believe something wrong has happened. While the OPP will investigate any criminal issues pertaining to the above briefing, it is the Attorney General that is responsible for enforcing MFIPA legislation. Therefore, my recommendation is that Council give consideration to passing a motion requesting that in addition to the OPP, that the Attorney General investigate the records destruction issue and pursue charges as appropriate. In conclusion, I am of the opinion that the matters shared with Council today that took place between 2018 to 2022 are of a highly questionable nature. I have no way to know if this is the extent of the questionable behavior. All we know is that the CAO and a small team around him were working very hard to hide something. Given that the town does not have line of sight on any personal financial implications that may have resulted, we have requested assistance from the OPP to investigate those aspects. And with that, I'll happy to take any questions.
Thank you very much, Andrew and John. Questions or comments from members of council? Councillor Belanger.
Yes, thank you, through the mayor. I didn't know into what detail you were going to enter into 3 of the items that were discussed this morning. And possibly it would maybe be a later date that we delve into some of them, but I would like to make the public aware of one situation, and that's why I requested a motion that we can speak to in-camera items on these 4 instances. Related to the contract of the beachfront, Council was only allowed to view that document in hard copy. We had to come into Town Hall under the supervision of the clerk and review a very technical 54-page document. And we weren't allowed, we were told we weren't allowed to take notes or photos or anything. When I arrived, I said to the clerk, because I'm going to take notes, but I will leave the notes with you, and I would like to have my notes back when we arrive in council to discuss this contract. I did that. When we arrived in council, it was decided they wouldn't return my notes to me, although obviously there had been no chance of confidentiality breach because the notes were in the hands of the clerk the whole time. They asked for a legal opinion, and the legal opinion was, well, the other counselors didn't have the opportunity to take notes, they weren't told to, so we're not giving you back your notes. Fortunately, I was still under 70 then and had a pretty good memory, and I kept council in closed session for approximately an hour and a half to discuss in detail why that contract was not in the best interest of our community. The most grievous part of the contract was that it allowed the developer to sell the land to another party who had never been involved in the RFP and really with no plan to develop, but that was one of the options that they could have. They, on their own accord, without any interference or any say from council, could determine that the market was such that there should be up to a 2-year delay. It could have been 3 years, 2 or 3 years. So in principle, they could have held that land for 5 years and then sold it with no plans for beachfront development, which totally negates the whole purpose of the RFP in the first place. There was an interest-free loan that would have saved almost as much interest as what they were planning to present the town as far as community improvement dollars. And I'm just hitting on a few of the highlights, and I would hope at a meeting in the future that we would look at that contract in detail and share with the public. It is my opinion that had I sat down with any member of the public and gave them the reasons why I voted opposed to the contract of the selling of the beachfront, 100 of 100 residents would have opposed it. Yet 6 members of the previous council approved that. It was unfathomable to me. It was grievously not in the best interest of our opportunity. I want to further just say that there's a component of our residency that aggressively supported these actions in the last council, and they continue to provide misinformation to discredit this council. And I hope the public realizes when they see those social media posts that they understand that these are the people that grievously supported this past council in these decisions. And hopefully what the public learned today will give us very little appetite to give those individuals any traction in the future. Thank you.
Thank you, Councillor Boulanger. Other questions or comments from members of council? Seeing none, I have certainly a few comments to make. Ladies and gentlemen, as I'm sure you're aware and hearing this is quite concerning. It is quite concerning to the municipality, it is quite concerning to our staff, and it is quite concerning to this council. But I think it's important to point out here, first and foremost, that whatever may have been done properly, improperly, whatever may come of this, I don't believe at this point there should be any negative impact on Zancor, Mr. Cordellucci, or the developers. Developers are business people. They approach private landowners, they approach municipalities, and they approach with a deal and an offer in many cases like this. They'll ask for the world, like many of us will do when we buy a house. And if the seller decides to give them the world, they'll take it. Doesn't mean they've done anything wrong. It's called the art of negotiation, and they're very good at it. So I think that is important. In this case, Zancor is a upstanding business partner of this community, I will say, as a developer here for many, many years, has developed a lot of homes, has put people in a lot of quality homes, and they continue to be a partner and a friend of this community. And so I just think it's very important that we be clear on that. The CEO and the mayor, the CAO and the mayor, who is the CEO of the corporation, have a fiduciary, and I would argue an ethical and moral responsibility to do always what is best for the community. As a matter of fact, mayor and council all swear an oath to that. And to hear that information was withheld from the majority of council by two top officers in the corporation is very discouraging, because it not only puts a blemish on them, in my opinion, but it puts a blemish on councils across this province, this country. And it's wrong in every way I can imagine. Whether you like or agree, council, every member of council has a responsibility and a right to have all the facts placed before them before they make a decision. It's also concerning to me that on many of these situations that we've heard of today, I do not recall a time where any other member of this council, with the exception of the odd exception, had a single question to ask about any of these transactions. One member of this past council has 40-plus years experience in commercial, residential, and development lands. 40-plus years experience. A whole bunch of letters behind their name on their card. Knows real estate and values very well, and yet had zero questions, or very little, if any, on these transactions. And important to point out that that individual also has done transactions with the parties involved here, both on the TPAL lands, both with the developers, as well as many other developers in this community. Yet, seeing property sold below value and below an appraisal, no money exchanging hands, promoting or asking or agreeing to purchase lands, not a few dollars, but millions of dollars above the value of that land, 40-plus years experience and has no questions. I find that very concerning. Back in my last term of council, and the council of the day decided to speak with Mr. Cortellucci, who was very gracious and agreed to offer up lands as a donation for redevelopment of the hospital in Collingwood. And it was always interesting to me that my deputy mayor fought this on so many reasons and so many occasions, although I never understood why. And here we are today. Records destruction. The municipality has had for many years policies and procedures in place with how we deal with documents and destruction. And to find that we have individuals here with many, many years' experience, not only as municipal employee, but as members of council, didn't follow these policies and procedures, yet boasted on a regular basis that we have to follow policies and procedures. To think that every single member of council's emails are wiped clean, with the exception of one, the one who questioned so many things that was happening. is almost unbelievable. When I became mayor in 2014, given that honor and privilege, my predecessor, God rest his soul, His Worship Cal Patterson, left me with an office full, every drawer full of everything that he had done, or just about anyway, in the past in this community, all his files, so as that I would have that corporate memory. And when I left in 2018, I did the same for my, Mayor Bifolchi. Yet in this term of council, when first day I was able to get into my office, I was left with a desk and one paper clip in the top left-hand drawer. Not a stapler, not a file folder, nothing. I think it's important to note that this has not been, is not, and will not be a witch hunt. It was made very clear, I think, I know to myself and to members of the council-elect at the time, that things were happening that didn't seem right by members of the public and by members of staff. And I know that the CAO has already touched on this, but I did sit down and talk with council-elect, which we received legal advice on that we could do, because we were not elected to, we were elected, but we're not in office. And it was decided that we send a letter on behalf of council-elect to the CAO asking that no documents, no files be shredded, destroyed in any way, shape, or form. There were other things that we talked about, or I talked about in that letter, and the CAO did respond in an email, sorry, not a letter, an email. But he refused and neglected to answer that one question. And that is to assure council-elect, although we knew we didn't have the authority, but to assure us that no destruction would happen. And because he refused to answer that, I then sent an email to the Chief Information Technology Officer and the clerk, and received emails back indicating that nothing had been destroyed, nor would it be. Yet to know now that there was a mass frenzy, and I say frenzy because that's what it was. In a short period of time, a week or two before the new council took office, to destroy records. Hundreds of thousands of records, which I believe leaves this municipality in jeopardy. And so it's not a witch hunt. This council, people sitting at this table, these staff members here today, are all about doing what is best for you, the taxpayer. This council is very much aware that we swore an oath to do what is best for this community. And so, as the CAO has indicated, we have turned this over to the Ontario Provincial Police. I believe that we should be asking the Attorney General as well to look into this. And I would ask that the clerk has prepared a resolution to that point. If you would please read that now, Madam Clerk.
Thank you, Your Worship. Based on the discussion, the following motion is before Council, that the CAO's presentation on the Wasaga Beach Investigation briefing be received, and that Council direct the CAO to contact the Attorney General to request an investigation into the record destruction matter.
Thank you, Madam Clerk. Council, you've heard the questions. Any comments or questions? Sorry, you've heard the resolution. Any questions or comments? Seeing none, could I have a mover and a seconder, please? Deputy Mayor Snell and Councillor Belanger, all in favor? That motion carries unanimously.